Welcome to EUPrivacyForAll, Session 27 on GDPR, Notification of Data Breaches to Supervisory Authorities, Article 31. European Parliament suggested to drop the 24 hours deadline initially provided by EU Commission, and that the data breach should be notified by the controller without undue delay, starting after the establishment of a data breach. The information to be provided by the controller may, if necessary, be provided in phases. This suggestion was retained. On the contrary, the supervisory authority, keeping track of all types of breaches notified in a public register, was not in the final draft. EDPB, being entrusted with the task of issuing guidelines, finally was retained too. On its side, EU Council added a piece of evidence that it's only based on the risks for data subject that data breach notification should be implemented, adding the fact that a breach might be likely to result in a high risk for the rights and freedoms of individuals. This was, in the end, let down in the final draft. Also was retained the fact of dropping 24 hours as EU Parliament, but for a 72 hours deadline. In the final draft of Article 31, it is retained that the controller, and the controller only, shall notify to the supervisory authorities that is competent within 72 hours after having become aware of the breach. But also it is mentioned that it is where it is feasible. So this is to be determined. Otherwise it would be without undue delay, but with reasoned justification in cases where the notification was not provided within the 72 hours deadline. A big caveat is to pay attention to. That is to say, no notification should be implemented if the personal data breach is unlikely to result in a risk for the rights and freedoms of individuals. The processor, on his side, shall notify the controller without undue delay, without having a specific deadline, like 72 hours being mentioned. The following paragraphs of Article 31 describe what should be notified. So, the nature of the personal data breach, that is to say the number of data subjects concerned, and the data records that are also concerned, the name and contact details of the data protection officer or of any contact point, the likely consequences of the breach on data subject, and the measures taken or proposed to be taken by the controller to address those issues and to mitigate possible adverse effects. As proposed by EU Parliament, the information may be provided in phases. And finally, there is an obligation for the controller and the controller only to document any personal data breaches. Recital 67 demonstrates that the controller has a tie obligation to notify within the deadline of 72 hours after being aware of the breach, because unless he would be able to demonstrate, in accordance with the accountability principle, that there is no risk for the rights and freedoms of individuals, he will have to notify or explain about the reasons why he did not do so. Other provisions in GDPR frame the personal data breach and the technical and organizational measures that should be adopted by the controller. Articles 38, 53, and 66 laid down how the data breaches can be framed through codes of conduct, investigative powers of supervisory authority, and European Data Protection Board guidelines, recommendations, and best practices. Currently, the directive does not frame data breach notifications to DPAs. However, opinions released by Working Party 29 do. What should accountable data controllers and processors get prepared for? First, controllers will have the obligation to notify without undue delay and, where feasible, not later than 72 hours after being aware of the breach. Unless, and this is a big exception, the personal data breach is unlikely to result in a risk for the rights and freedoms of individuals. That is to say that concretely, controllers will have to assess the effective likelihood of privacy risks and document this assessment in order to demonstrate compliance. If not notifying within 72 hours, controllers will have to hand over a reasoned justification. On their side, processors will have to notify the controller without undue delay. The controller will have a documentation obligation, but he might hand over information in phases. The notification will at least include information about the nature of the breach, name and contact details of the data protection officer or any contact point, the likely consequences of the breach, and the measures taken or proposed to be taken by the controller to address the risks. Usage of codes of conduct might help demonstrate compliance. And finally, controllers shall anticipate DPA's orders on communicating breaches to data subjects. What will be interesting now is getting EDPB guidelines and recommendations or best practices on 3 topics: undue delay, formats and templates for notification, and what constitutes a risk.